So thank you guys all for being here today. My name is Angel Orozco. I am your guys' sales executive for Fidelity National Title. And in addition to providing title and escrow services, we're always trying to find ways to add value to your business. So with me today, I have Bialick, who's an attorney at law, and he's going to be going over a lot of information on how to hold title and just trusts and probates. So I will go ahead and let him take over. Barry, thank you for joining us here today, and we appreciate your time.
Thank you. The information that's listed there, much of it you'll be familiar with already. But there's new things coming up, especially in light of President Biden's administration and their talk about changing things, specifically adding or increasing taxes, deleting or reducing the step up in basis, things of concern that you should be aware of, although it has not become law yet. Let's start off with the simple aspects in terms of holding title. You have a single person, they can have it in just their name. If it's more than a single person, two or more, they can hold it in its tenants in common. Tenants in common, as you remember, do not have to be equal interests. For instance, one can be 70% owner, one can be 30% owner. LLC, it's an interesting thing. If you have a property that you decide to put into an LLC, and most people use LLCs to shelter the property and to shelter them from liability. If you start off with two owners and they have a, let's say, 30-70 split on the ownership and they transfer it into the LLC, you have to be careful in that the LLC, the ownership of the LLC must be the same. Otherwise, it will be considered a transfer that's subject to reassessment. So you need to pay close attention to ownership. Ownership before and after should be the same. In that case, there wouldn't be a reassessment. Corporation, transfer in, it's a different setup. With a corporation, it's a more of a formal structure. The LLC is more like a partnership, but with corporate protections of a type. Either one can be used. Generally these days, most people I see who have real property use LLCs because they're much more informal and they're easier to work with. And with an LLC, tax losses and benefits go directly to the owners. So it's a good entity to have. Corporations, if you want the benefits of the tax losses or you want the income to be reported by the individual, then you need to make the corporation a sub S corporation. Partnership and limited partnerships. Partnerships, again, two or more people. If you have a general partnership, which is what that's referring to, each of the partners is personally liable for any lawsuit or damages or debts. So let's say, again, we'll use our example of 30 and 70% partnership, general partnership, and there's a lawsuit and $1 million is owed. The people who won the lawsuit can go after the person who has 30% because he or she is more easily accessible and take the entire $1 million from the 30% owner. They don't have to just limit their takings to 30%. They can take the full amount. And then it's up to the 30% owner to look to his partner or her partner for the 70%. So I don't recommend general partnerships for the most part, just because of the liability issue. There is something called a limited partnership, which we see much less frequently. And limited partners are sheltered. What happens is you have one general partner and you'll have limited partners. They invest, and the maximum they're liable for is their investment, nothing more. They don't have any personal liability. The general partner, if it's an individual, has personal liability, or what we do many times is use a corporation to act as the general partner to shelter the individual who in effect is acting as general partner. Excuse me for a second. Any questions? I welcome questions while I'm talking. Am I that clear? That's great.
I don't see any in the chat box just yet, but I'll keep you posted if any pop up in the chat box.
Okay. Tenancy in common, we've talked about already. Joint tenancy. Joint tenancy, as you remember, is between two people or more. And the way it's set up is that, number one, all the joint tenants have to have equal interests. And then number two, upon the death of each joint tenant, it goes to the survivor. So if we have three, one dies, their interest goes to the other two. Now, this is really important. You got to be careful suggesting joint tenancy to people, because they may have a will that says everything they own goes to their spouse. Well, if it's in joint tenancy with someone else, or a brother, let's say, and the individual dies, nothing goes to the spouse. It all goes to the brother. So think very carefully before you start recommending joint tenancies as the way to hold the property. In fact, I would recommend that you let their attorney do that. That way you avoid liability. But just keep that in mind. It's a good device under limited circumstances. Next, we have under G, community property and community property with right of survivorship. Community property is a wonderful thing, can only be used between husband and wife or two married people. And the interest in each case must be equal. It always has to be 50-50. Cannot have 30-70. And what happens is that upon death, let's say there's no will, community property normally goes straight over to the surviving spouse. There's a procedure for doing it, but it would go over. Another way of holding community property is with right of survivorship. And that works, like joint tenancy, in that when a husband or the wife passes away, I apologize for my voice. When they pass away, it's a simple recording of a affidavit of death of joint tenant or of community property with right or survivorship, the partner. And what it does is it does something unique. And let me go back to community property. Community property, husband and wife, they buy a house for $100,000, and let's say it's worth $800,000 when one of them passes away. What happens is their basis, what they paid, $100,000, automatically goes up to the date of death value. And that's wonderful. So from $100,000, it goes up to $800,000, and the survivor, when he or she sells it, it goes free of all tax if she sells it or he sells it for $800,000. It's wonderful. It's a great gift. Community property with right of survivorship, you get the same effect, but instead of having to have a trust or going through court procedure, you just do an affidavit of the death of the partner. So it's much simpler, much less expensive. Otherwise, I generally recommend that community property be held in a trust, but we'll get into that in a little bit. Actually, that's the next item.
Can we ask a question really quick?
I'm sorry?
Can we ask a question really quick?
Sure.
Thank you. Tracy, go ahead and ask your question if you like.
Hey, hi, Barry. With husband and wife, title is community property, but they don't have the word survivorship in it. So just what if one person passed? Does it automatically goes to probate, or it doesn't?
Okay, it does not. It does not automatically go to probate. There's a procedure. And it's a transfer between spouses. That's what happens. Okay. But you have to initiate the procedure. You know, probate takes 9 months to 2 years. This can be done with, you know, you prepare the papers, you have the hearing, it's 3 months away or 4 months away, depending on how backed up the court is, and you're done. And that's it. It's fairly inexpensive. So no, it doesn't have to go to probate. It's even faster if you have it in a trust. In a trust, the biggest delay is the fact that we need a death certificate. So we get the death certificate, and then we can transfer the control of the community property over to the surviving spouse.
So, for example, if they don't have a trust, it's just, on title community property with not the word survivorship, then they have to do the procedure that you just mentioned, correct?
Yes, yes, but it's really informal. It's an easy procedure. I've done it on many occasions.
Thank you.
Oh, no problem. And what I'm saying is I would not be stressed if that was the situation. Where someone, is a survivor and it was in community property, but they didn't have it in trust. It's not a hard thing for an attorney an estate planning attorney or probate or trust administration, generally, like myself, we do all three, and this isn't a big to-do. And you get the step up in basis, as I said. Which brings me, I'm going to go back for a second. I want to talk about joint tenancy. You can have joint tenancy between a husband and wife, but if you do that, what happens is you only get the step up on the decedent's half. So if the decedent's half went up from 50 to 400,000, and the survivor's half has a basis of 50, then we'd have a new basis of 450. She sells it or he sells it for 800. We have taxes on that difference. So you got to think very carefully about using joint tenancy with spouses. Any questions on that item? Okay, great. Revocable living trusts, they've become incredibly popular over the last 20 years, and for good reason. They avoid probate. Probate is court administration of the distribution of a decedent's assets. And it can get pretty expensive given the service. It's not that probate's bad, it's just that probate requires a lot of work and court supervision, which is expensive. To go into a probate, just filing fees alone for the initial filing is about $500. And then when you vacate it, when you leave, ultimately, it's another $500. That's just those fees. And you're going to have other fees for certified letters and other costs that are incurred. It also takes 9 months to, as I said, 2 years. And every single asset that the individual owned is available for the public to look at. If you want, you can go to Orange County and you can look up John Wayne's estate. He didn't have a trust, and you can see what his estate was worth, where his landing craft, marine landing craft from World War II, what it was worth and which one of his kids he gave it to. You know everything about him, how much his spouse received. There is no privacy. Whereas with a living trust, it is never, ever part of the court. It remains private. The only time we end up in court with a living trust is that we're having serious problems. And that's when there's disputes. Sometimes what we'll do is we'll elect to go into court because we want the judge to rule on it. But otherwise, with a living trust, you avoid it. The other thing is that with probate, you have to pay fees for the executor and for the attorney up to 4% on the first 100,000, 3% on the next 100,000, 2% on the third 100,000, and then 1%, believe off the top of my head, for at least the next couple million. So on an estate of $1 million, as I recall, the last time I looked, it was around $21,000. And when you do a probate, the fees are based on the gross value. So if it's $1 million house and there's $900,000 in debt on the house, the fees are based on $1 million, not on 100,000. With a trust, there are two ways attorneys do it. Some of them just do it as a flat 1.5% fee or some other number, or as I do it on an hourly basis, and it just depends. Some are pretty straightforward, but when I have not clients, but siblings fighting, that's when the costs go up. And sometimes siblings fight just because they run the costs up unnecessarily. For instance, I had one twosome, brother and sister. They wouldn't talk to each other. So one would tell me something to pass on to the second, and I would tell the second. Well, basically that's double billing. It was crazy. And I told them, I said, you realize that I'm double billing you. It's not my choice, but I'm using extra time. If you talk directly to your sibling, I don't bill at all. And the response was, I'd rather pay you than to talk to my sibling. People are weird. I mean, that's how much anger there was between them, and it was sad. So what I'm saying is that dealing with attorneys, you have to be smart about it. You need to know what your goals are, and you want to get everyone on board, going straight, going for a target and working together, and you save yourself a lot of money. And trusts save incredible amounts of money. Actually, when the probates come up, it's not a bad thing for me, as I said, because of the fees. I don't recommend it if someone comes to me, but sometimes, if it's after the fact, after someone's died and they haven't done anything, we have no choice. We can't get around it. Any questions on this?
I have a quick question. How long does it take to draw up a trust? Let's say somebody is, at their final days and they, finally came to their senses. How quick can you make something like that happen?
Well, I've done it in an afternoon and gone to the
Wow.
hospital and got it done. Now we have to review it there. Sometimes it's a little difficult because they can't see anymore. And so you have to read through it. I mean, the highlights and things of that sort, but it can be done. There's a premium, of course, charged for dropping everything and getting it done. But it's, in fact, I did one at Kaiser not that long ago. And it was a real, I got paid, well, but it was really, I was very pleased because it was going to go, he didn't have anything, he didn't have a will, anything. So it was going to go to his heirs at law, and they were only distant cousins who he didn't care for. And I came in and we got the people he did love, friends, and companions, and we got it to them. And really, I felt good about it. It was one, that's, those are the good days. That's great when you can do things like that.
Absolutely. Thank you.
No problem. So tenancy in common, generally tenancy in common, just so you know, if you have like a 1/3 interest and you have a will or a trust, that directs where it goes, and a deed is generally used. And that's done through, well, if it's done through probate, it's done through the probate, and it's part of a distribution order. If it's done through a trust, it's simply a deed out of the trust. It's pretty straightforward. Joint tenancy, that's even easier, because you just do a affidavit of death of joint tenant and you record it and you are done. The problem I see, and you need to counsel your clients when they come to you, and you have to be careful with this. What happens is that a couple will have, a married couple will have their property in joint tenancy, and they want to sell and they want to move away right away, and they want everything done immediately. And you look at it and you see it's a joint tenancy. Oh, great. Just a certificate of death of, I'm sorry, an affidavit of death of joint tenants. You go and record it. Well, here's what you've done. You've destroyed the double step up in basis that these people had, because they had a declaration somewhere saying it was community property. So you have to be very careful with that, later on they discover this. They could have not paid any taxes, but you told them to go with joint tenancy, and there's a problem. It's a liability. So be very careful when it comes to suggestions of this sort, and always include a proviso saying, it is my recommendation you talk to an attorney about this. It protects you, and it really is. You're doing the best thing you can for your clients. Any questions on that? Great. Well, we'll move along with community property with right of survivorship. Again, a certificate of death is attached to an affidavit of death of the partner, and it's recorded, and it's done, and you get a double step up in basis. I really like this. Sometimes people will come to you and they'll say, oh, my husband and wife, we want to buy, this property. Okay, great. You get the property. How are you going to take title? Do you have a trust? No. Do you want to set up a trust? No, not at this time. Community property with survivorship is the best thing for them. Now, mind you, I talked to you about can you still hear me?
Yes.
Okay, I'm sorry.
We can hear you, but it looks like your camera turned off.
Yeah, it did. I don't know why. Well, then you don't have to look at me. I don't know why.
Well, we can still see you. Or hear you, I said.
Oh, yeah. I don't know why it turned off.
That's okay. We can hear you.
Okay, we'll go ahead. With the community property with right of survivorship, you get a double step up, and it's great. It's a wonderful thing. And then when they're ready, they can put it into trust. Sometimes these are very young couples. But what I wanted to say, is that when I talked about the step up in basis, it's a double-edged sword. It's also a step down in basis if things go sour with the property. Let's say they discover a toxic dump, and you go and you want to sell it or someone dies, the property goes down in value for your basis. So, I'm saying community property with right of survivorship. In this area, odds are very high that property will go up in value. So you're pretty safe. Out in the valley, I know things are better. I'm talking about the Sacramento Valley, San Joaquin Valley, but for them, it goes up and down. So you got to really monitor it. My parents invested in a property. It was a retail location, and they hadn't community property and hadn't set up, and the place started going under, and I mean rapidly under. We took it out, we put it into joint tenancy, and then it just went down in value. And actually, when one of my parents passed away, we only had a step down in basis as to the one half, not both halves. So what my corollary is, you need to watch out, with community property as well. I believe in community property, but it's something you have to pay attention to. Okay. I trust I'm not talking just to the my
We're
monitor.
listening.
Okay.
I actually have a question here for you, Barry.
Okay, go ahead. I can see you now.
Yes.
happened?
So if the clients are not married yet
Yes,
and they bought the property as joint tenants, then
Yes.
1 year later they get married, do they file a document to the city to change the status to community property with right of survivorship, or is it automatic after they get married?
it is. That's a great question, Angel. It is not automatic. They need to know this. What happens is there are two ways of doing it. You can do a formal declaration. It's 2 pages saying that they're married, they hold this property in joint tenancy. However, they now declare it to be community property. The other way is they just execute a new deed. They say, as joint tenants, we're transferring it to ourselves as our community property with right of survivorship, or just community property. But they do have to take the initiative. It's really important. That's an excellent question.
Got it. All right. Thank you.
No problem. Okay, in trust, real easy. All we do is, once we have the affidavits of death of co-trustee or predecessor trustee listed, we just, assuming everything's in order, we've had the debts paid, we have the distribution set up, we just do deeds. It's really easy. The attorney does the deeds and we're done. It's a great thing. I really like it. We can get it done in 2 to 3 weeks, assuming that there's no estate tax return. And there, let's say it's going to 1 or 2 people and they're all in agreement. It's just a matter of getting the death certificate and then carrying out the instructions in the trust. By the way, a will does not avoid probate. So some people have come to me, well, I have a will. No, all that does is it directs where the property is going to go. If you don't have a will, we use the laws of intestacy, which is the way the state of California, in all its wisdom, has decided how it should go. So, your clients hopefully want to have control of their estates and where it's to go. For instance, as I said before, I had that one, he just had heirs at law and they weren't cousins that he cared for. It's what he accumulated in his lifetime. It should go to where he wants it to go. I really do believe in this. Of course, having said that, it took me over 5 years to put an estate plan in place after I was married. So I'm like the shoemaker whose kids don't have shoes. You know, I'm too busy at work, dear. I don't have the time. So it's easy to let it slip, but you know, things happen. So I'm glad she finally forced me. Okay, probate. The big bugaboo that I recommend trying to avoid if at all possible.
Before you go there, can I interrupt you with one more great question?
Sure. Go
All right,
ahead.
so this is kind of like on the flip side. If a person is single when they purchase the property and later get married, is the property considered sole and separate property prior to marriage, or is it by default considered as community property?
That's an excellent question. God, Angel, you're on.
That's
really
not me, that's coming from Larry.
All right, well, great question. And everyone should know this. If you buy your property before getting married, it is 100% yours. The day after you get married, your salary is half hers or his, as the case may be. To the extent community property funds are used to pay the mortgage and to make the improvements on the property, then the spouse, the newlywed wife or husband, gains an interest. The community gains an interest in the property, in the house. And it continues to grow in interest. Each year that they pay the property taxes, they pay the mortgage with community property, the other spouse gets an interest. So upon divorce, if God forbid that's what happens, they'll look at how long money was paid, how much was paid before, and they'll look at the appreciation of the property, and a certain percentage will be allocated to the community. So the antidote to it is a prenup. You can do a prenup, extremely unpopular, but it can be done. Another way, poor man's way of doing it, is you have it in a living trust. The single person puts it in the living trust. And if it's only one house, then what he or she has to do is make all payments for money from separate property. Let's say they have an inheritance and they have a couple $100,000, and that's their separate property. They keep it separate. They never mix it with any joint accounts, and they use that money to pay all the bills on the house. So it is a touchy thing that should be that needs to be thought through before the wedding. And as I said, postnuptials aren't real popular, but you know, postnuptials don't need to last forever. I mean, just let's say you're gun shy, you've been burned once. So you put in a postnuptial. You can put in that it's that it'll terminate in 9 years' time or 6 years' time. In other words, you just want to make sure that you don't get burned. And as much as you love them, you know, people do change or circumstances arrive, things happen. In this way, there's an out for that person who has the separate property. But for the survivor, for the other one, I'm sorry, the one he or she marries, they also get to be a part of this, you know, and share in it. And mind you, this prenuptial agreement, at least the ones I do, always say that despite the prenuptial agreement, either one can put in their will or trust provisions for the other. So even though it says that the other has no rights to anything, you can still give it to them. You're not stopped from doing that. Any further question along those lines? Questions?
Yes, there's a few here. So this
Oh.
one, I think you answered it, but just in case not, if the finance is paid by a sole and separate account, then would that be sole and separate?
Yes. You
Okay.
make sure you never mix funds. You never put any salary or anything of that sort in there. You know, the optimum would be if you had a separate property house and you pay, and then you and your spouse went and bought another house, community property, okay? And you rented out the first house and you paid all the fees and all the expenses from the rent, because then it keeps it separate all the way through. The problem, this is a problem that I've run across a number of times, is that after, let's say, 10 years, you know, something will come up, they'll want to refinance. And the spouse will say, you know, I've been working on this house. I scrub the floors. I'm being sexist in this case. I'm saying, you know, it's a woman, let's say. And she, you know, I've been doing the gardening. I helped you paint the house. And you're telling me I have no interest in this house? That all my sweat is for naught? It all is yours? And I'm not a counselor, but it, you know, where the people, my recommendation is generally involve your wife, you know, or involve your husband, bring them in. If you feel you have a good marriage, they've, you know, you've had a couple kids together and you believe in each other, then put it in joint tenancy, you know, or I'm sorry, community property. Make a community property half and half. Yeah, you risk losing half, but you know, maybe this is something that will really cement the relationship. And the ones that I have done that for, or that I suggested that to, they've all stayed together. So for what that's worth.
All right, thank you. All right, a few more questions for you.
Sure.
If the property is in a trust and one of the spouses dies, then would there be the same advantage of step up as community with survivorship?
Yes. You just have it in the trust, and as long as it's community property, you're all set to go. You get a double step up. And if the property's in the trust, you also get the 250,000 exemption, you know, in terms of selling the property. Together, you have 500,000. So having it in the living trust will not prevent you from taking advantage of these tax provisions. But I want to advise you that you have to be aware that living trusts do not shelter the individuals from liability. So I have my house in a living trust. And if someone sues me and they win a big judgment, they can go after my personal assets, including those in the living trust. So it has to be an irrevocable trust, or there are other types of trusts. But for the most part, for what you're doing, you're not going to run across that unless it's someone who's single and just buying for their own account. But anyhow, it is something you should be aware of.
Okay, thank you. All right, we have one more here. So on title, husband and wife as community property, but it does not have the word survivorship. Can they go to the city and fill out a form and add the word survivorship in it if they don't have living trust to avoid probate later?
Yeah, all you do is a simple same deed, but they're going to give it to themselves with right of survivorship. So you're just doing the same deed over. You need a PCOR, preliminary change of ownership report. You can talk to Angel about that. And you need a deed. as well. And again, talk to Angel about that. It's going to be the same thing as what you had before, but with the right language. And then you sign it off and they'll record it.
Thank you. All right, that's all the questions for now, Barry.
Okay, so here we have this probate. It rolls around, and what happens is you have the right to elect Independent Administration of Estates Act. So the representative under this act has the authority to go ahead and sell the property, sell that house or properties without going to the court for its approval. The only thing you do is you send out notice to all the beneficiaries that you're going to be selling this house. And this is how much you're going to sell it for, and that kind of thing. If you don't have this, you do have to go through the courts, and the court needs to confirm the sale price, and it has to be at least 90% of the value that the probate referee gave that property. Probate referee values all property in the probate estate. And he'll go and make his determination. And that value, the selling price can't be less than 90% of that value. But what's really interesting is once you get to court and you're there, let's say you're at 92% or 95%, anyone in the court can bid in the court a higher price, and they can buy it in the court right then and there. So they come in and they buy it. You don't want that happening. Maybe you do. Let me just revise that. But your client, is the people who are buying it. If you're representing the buyers, they're going to be mad as heck. And they're going to ask why you didn't, if they're knowledgeable, why this wasn't under Independent Administration of Estates Act. And, this, of course, going to court and selling it there, guess what? The attorney charges extra fees for doing a sale in court. And that's on top of those fees that I was talking to you about. So really the best thing is to go with the Independent Administration of Estates Act, which the executor or the personal representative can request. It's not a big to do, and they don't have to, and they can request it after the ball starts rolling. But, if you feel that there's going to be problems, as I said, with different would-be beneficiaries arguing it should be higher or something of that sort, then go to court and you get the judge to say it's okay and take the risk of a sale. It doesn't matter. You got to protect the representative is your client, and so you've got to protect them. And just as I do, I protect them. I don't protect the probate estate. I protect the executor, and that's what your job is in this case. And sometimes it's more expensive going to court, but it's the best thing for you as well as the client. Okay, any questions on that? A little long-winded there, but that's it in a nutshell.
Right,
No
I don't see any more questions in the chat box, but if anybody has any more questions, please feel free to speak up.
If you have my outline, you're welcome to call me later on about questions. I'm happy to discuss it with you, no problems.
Yep, I also left Barry's contact information in the chat box, so his phone number and his email address is there.
Okay.
And I believe Olivia and Stacy will be posting this video to your guys's internal site. So you guys could always go back and watch it again if you need to.
Does it, how long does the video last? Is it forever? Or does
Forever,
it
Barry.
self-destruct after 10 days? Like Mission Impossible.
Yeah, so it looks like Olivia said it'll be posted tomorrow. Yes, it'll be here for probably a long time. So thank you
I'm
guys
just
all for being
curious.
here.
Thank you all. Thank you, Angel.
Thank you, Barry, for
Bye.
your time and your knowledge.
Oh, my pleasure. Take care, everyone.
Okay,
Thank
bye,
you.
everybody.
Thanks, Barry.
Bye, everyone. Thank
Bye
you, Barry.
now.